Now we have, great. So as we get started, I'd just like to welcome the members of the St. Thomas More Society and thank them for coming to join us. The St. Thomas More Society is a Catholic philosophical organization dedicated to the dialogue between faith and reason and trying to teach young Catholics the teachings of the Catholic doctrine and help them to grow deeper in their faith. It's led by Dr. Stephen Hudson, who's in attendance, and they bring a number of their members, so we welcome them. Also, welcome to anyone who's from the James Wilson Institute, which is the James Wilson Institute on Natural Rights in the American Founding, which Professor Arkes is the founder and director. We're very glad to have you here as well. And then also welcome to anyone else who's coming, our distinguished friends and guests. So with that, I will get started by introducing our esteemed speaker, and then let him take the floor. Hadley Arkes has been a member of the Amherst College faculty since 1966, and since 1987, he has been the Edward Ney Professor of Jurisprudence. Since 2016, he has assumed emeritus status. He has written 5 books with Princeton University Press, namely The Bureaucracy, The Marshall Plan and the National Interest, The Philosopher and the City, First Things, Beyond the Constitution, and The Return of George Sutherland. But his most recent books have been with Cambridge University Press, including Natural Rights and the Right to Choose and Constitutional Illusions and Anchoring Truths, the touchstone of the natural law. His articles have appeared in professional journals, but apart from his writing in more scholarly formats, he has become known to a wider audience through his writings in the Wall Street Journal, the Weekly Standard, and National Review. He has been a contributor also to First Things, a journal that took its name from his book of that same title. For 8 years, he wrote a column for Crisis Magazine under the title of Life Watch, and he has carried over that concern as one of the band of friends who formed the new web journal, The Catholic Thing. He was the main advocate and architect of the bill that became known as the Born Alive Infants Protection Act. The account of his experience in moving the bill through Congress is contained as an epilogue or memoir in his book, Natural Rights and the Right to Choose. Arkes first prepared his proposal as part of the debating kit assembled for the first George Bush in 1988. The purpose of that proposal was to offer, quote, the most modest first step of all in legislating on abortion and opening a conversation even with people who called themselves pro-choice. Professor Arkes proposed to begin simply by preserving the life of a child who survived an abortion, contrary to the holding of one federal judge that such a child was not protected by the laws. Professor Arkes had led the testimony on the bill before the Judiciary Committee of the U.S. House in July 2000, then again in July 2001. The legislative calendar was upended in the aftermath of September 11th, but in March 2002, the bill was brought to the floor of the House, where it passed unanimously. To the surprise of Professor Arkes, the bill was brought to the floor of the Senate on July 18th by the Deputy Majority Leader, Harry Reid, and passed in the same way. On August 5th, President Bush signed the bill into law with Professor Arkes in attendance. Professor Arkes has been the founder at Amherst of the Committee for the American Founding, a group of alumni and students seeking to preserve at Amherst the doctrines of natural rights taught by the American founders and Lincoln. That interest has been carried over now to the founding of a new center for the jurisprudence of natural law in Washington, D.C., the James Wilson Institute on Natural Rights in the American Founding, named for one of the premier minds among the American founders. And with that, please join me in welcoming our speaker, Professor Hadley Arkes.
Okay, thanks for that. Thanks so much, Tom, for inviting me. That stuff sounds like ancient history now, except we've gone back to that bill to restore the penalties that were stripped away from it back in 2000. So we have the new Born Alive Survivors of Abortion Act, rather stuck in the Senate. Something you said a while ago recalled to me that entertainment that Richard Lederer used to offer the world, some items drawn from the term papers of undergraduates, and it was an inventory that contained items of this kind. That Socrates was a Greek teacher who died from an overdose of wedlock. That Louis Pasteur discovered a cure for rabbis. And Sir Francis Drake circumcised the world with a 100-foot clipper. Now, I know we don't get papers of that kind from Boston College. I used to say that this is one of those faculties into whose hands a parent would be comfortable in delivering his own children. I know that I still have many friends. I think Bob Faulkner, Mark Landy, Susan Schell, the great Peter Kraft, the irrepressible David Lowenthal. So thanks so much for inviting me in. I'm rather touched that you were open to hearing about the argument within the conservative camp over jurisprudence, over natural law and moral truths. But this, since this is a meeting of the Republicans, I should take just a minute to say something on the situation of the Republicans. And the main point I convey, I think, is that the Republican Party really is not shattered or in disarray. It's in very good condition because people in the country have just a clear sense of who the opposition is as an administration and Congress of the left extend the powers of the government in a way that's destructive of the economy and of the families. So if people recoil from this new surge on the part of the government, they know exactly who the opposition is, and the party is gifted with so much talent right now and rising stars. But the problem now is that the left is not really out to win elections, but to drive the Republicans out of existence, and do that by, say, altering elections with mail ballots, adding another state or two, allowing an influx at the border on part of immigrants who could tip the political balance in New Mexico and Arizona. But what is even more novel in this current crisis is that there's a move on not really to drive Republicans out of public life, but to bar them from private employment as well, in law firms and corporations, anyone who'd worked for the Trump administration. But if they come through this next election and have a further surge of success in the Senate and the House, the party could be coming back with renewed energy, I think, and dynamism. Okay, I offer that as a prelude to the talk. I'd like to begin by recalling that night in November 2008, when Barack Obama was elected president. And he addressed a throng in Grant Park in my hometown of Chicago. The very next morning, I had an email from Jim Stoner at LSU saying, "Did you see last night?" He said, 221? 221? We built this country Khalistan by Khalistan from 221 years. We said, well, what's the difference between that and Lincoln saying at Gettysburg, 77 years ago, our fathers brought forth this nation. If we count back 87 years from Gettysburg in 1863, we don't end up where Obama ended up in 1787 with the drafting of the Constitution. We are brought back, as Lincoln had it, to the Declaration of our Independence and the articulation of that first principle, which he called the father of all principle among us, that all men are created equal and the only rightful government over human beings must depend on the consent of the governed. The task of a constitution is kind of to establish a structure, a practical structure of governance consistent with that principle. The first constitution didn't work. It simply embedded all the centrifugal tendencies at work in the country. So the constitution we have now is the second constitution. So Lincoln and Justice George Sutherland remind us that the Union is older than the Constitution. The Constitution was made for a more perfect union. Lincoln drew on Proverbs that a word fitly spoken is like an apple of gold in a frame of silver. The frame was made for the apple, not the apple for the frame. The Constitution was made for the Union, not the Union for the Constitution. So again, the task of forming a constitution was a matter of drawing on those principles that were there before the Constitution and shaping a structure of governance that would be consistent with those principles. And so the American founders knew a world of law and principles of moral judgment that were there before the Constitution. Now, you might recall here John Locke's set of three questions when he asked, what is the source of the law? The legislature, which makes them. Well, then what is the source of the legislature? A constitution that tells you whether you have a legislature, how many chambers it may have. But then he asks, what is the source of the Constitution? It must be, he said, some source wholly antecedent to positive law and the Constitution, some deep principle antecedent to positive law, affirming the right of a people to be governed under terms of its own acceptance. One of the most remarkable attributes of lawyers like Alexander Hamilton, James Wilson, John Marshall, is that they had this knack of tracing their judgments back to those anchoring principles that formed the ground of the law and were there before the Constitution. So in that vein, my dear friend Greg Katsas, who's now Judge Katsas on the DC Circuit, Greg Katsas, during the oral argument over Obamacare in 1212, and Greg Katsas took the first day and he drew on that argument from John Marshall in the old Dartmouth College case, where Marshall said that to impose upon people a contract they did not want, in this instance, buying medical insurance, imposing upon them a contract they did not want could be as bad as impairing the obligation of a contract they had willingly made. And Justice Joseph Story would argue later in his commentaries that that principle would be true even if there were no Constitution. And John Quincy Adams would argue later that that right to petition the government is simply implicit in the very idea of a regime of law or a Republican government. It would be there even if it hadn't been mentioned in the First Amendment. It would be there even if there had not been a First Amendment. It would be there even if there were no Constitution. But then some of our friends turn around and say, well, are you saying we don't need the Constitution? You don't need the... No, that's not what we're saying. We're talking about matters of structure now. It really is quite important for me, others to know, whether a state may make its territory available as a naval or military base for foreign power. Or even more critically, whom will the army obey when a president dies and who succeeds him legally? These are critical matters of structure. We don't notice them as much because we're not litigating about them. My late beloved friend Daniel Robinson, who did seminal work in the neurosciences, wrote 18 academic books, spent his last 20 years at Oxford lecturing on Kant and Hume and Thomas Reid. Dan said that he wanted, as the inscription on his tombstone, he died without a theory. He died without a theory. When he said that, it was part of an appeal to the common sense philosophy of Thomas Reid, the Scott philosopher, who was read by the American founders. The appeal to those axioms of common sense that any ordinary or functional person simply had to take for granted in getting on with the business of life. And before he could begin trafficking in theories, and so before the average man would be bantering with David Hume about the meaning of causation, he knew, the average man knew, his own active powers to cause his own acts to happen. Now, some of us have followed Reid and found the ground of the natural law, as Robinson said, in those maxims of common sense that the ordinary man is compelled to take for granted. And that is where men such as Hamilton, Wilson, James Marshall, John Marshall found the ground of the natural law. Thomas Jefferson said, you could state a moral case to a plowman and a professor, and the plowman was as apt to get it right because he has not been led astray by artificial rules. Call them theories. But this is exactly what Thomas Aquinas was getting at, I think, when he said the divine law we know through revelation. But the natural law we know through that reasoning that is accessible to human beings as human beings. And in all my teaching over the years, there has been no better example of that, no example which, when heard, is more instantly understood than that fragment that Lincoln wrote for himself in which he imagined himself engaged in a conversation with an owner of slaves, putting the question, why are you justified in making a slave of the black man? Is it because he's less intelligent than you, with the more intelligent having the right to rule the less intelligent? Beware, you may be rightly enslaved by the next white man who comes along, more intelligent than you. Is it color then, with the light having the right to govern the darker? Beware again, you may be rightly enslaved by the next white man who comes along with a complexion even lighter than yours. The upshot here was that there was nothing one could name to justify the enslavement of black people that would not apply to many whites as well. And you didn't need a college education to understand this kind of an argument. Some of us have drawn on precisely that same mode of argument, simply a principled argument, on the issue of abortion. So we ask, why is that offspring in the womb any less than human? Doesn't speak yet, neither do deaf mutes. It doesn't have arms or legs yet. Well, other people lose arms or legs in the course of their lives without losing anything necessary to their standing to receive the protections of the law. And the upshot here is that there's nothing one could cite to remove that offspring in the womb from the circle of rights-bearing beings that were not applied to many people walking about well outside the womb. And once again, we point out that this is simply a species of principled reasoning. It could be understood across the religious divisions. You don't have to be Catholic to understand it. Before that has been the argument of the church, that we're not appealing to faith. The position of the church is a combination of the facts of embryology woven with principled reasoning, just the principled reasoning of the natural law. Okay? Now, it may be worth lingering with this point just a little longer, because it has a special force these days for Republicans, because one of the more dramatic changes in our politics over the last 40 years is that the division between the parties shifted from divisions over class, and those have been displaced now by divisions in the culture wars, and abortion has been at the center of those differences. In fact, the main interests of the Democratic Party have come to hinge on that as the central pin. And for many, as you know, that right to abortion has been seen as the real anchoring ground of privacy and personal rights, and it's displaced such things as freedom of speech and religion. Many interests may be compromised, but not the insistence on preserving a right to abortion with virtually no restrictions throughout the pregnancy, along then with the right to kill that baby born alive. We've seen the Democrats achieve utter cohesion now in supporting this, the most radical sweep of the right to abortion. And the party has been quite cohesive over the last couple of years in resisting that move to punish the surgeons who kill babies born alive. In order to see things in that way, Democrats have had to talk themselves into the notion that the offspring in the womb must be something less than human. And that is why Black Lives Matter says nothing about the Black lives lost in abortion in places like New York and Chicago, where the number of Black abortions often exceeds the number of live births. Those lives just don't count. And what do we make of the fact that Joe Biden staged a ceremony at the White House to mark the 500,000th death over COVID? He observed with deep gravity that this is more people than we lost in World War II, Korea, and Vietnam, 500,000. But that figure is dwarfed every year by the 800,000 plus abortions that are performed every year in this country. For Biden, those figures, those babies don't figure in the equation. They're not noticed because they've been filtered out for Biden and others for the things that count, the things that really count. Well, now this flows, I think you'll pause it for a moment. This all flows from that example of natural law reasoning I recall from Lincoln. It was simply a species of principled reasoning, accessible to ordinary people, accessible to people who are not burdened with a college education. To recall again my dear friend Dan Robinson drawing on Thomas Reed, we find the ground of natural law, in those maxims of common sense, that the ordinary man is compelled to take for granted in getting on with the business of life. They are so readily grasped that people may not be aware that they're even acting upon them. Now, what kinds of things could they be? Let me offer a couple, most central to our law. And if we begin with those axioms that are grasped even by ordinary folks, let me approach the problem in this way. What would you guess the proverbial man on the street would say if he learned that Jones, accused of a serious crime, was in intensive care, recovering from surgery at the time the crime was committed, or that Jones was heavily medicated at the time and had no firm control of himself, or that Jones had not been born when the crime was committed? I mean, does anyone doubt in the least that ordinary people, undistracted by theories, would quickly say, of course, Jones could not have been guilty of the crime. He should never be tried or convicted. That is to say, virtually everyone would back into that proposition that Thomas Reid and Kant in different ways took as the first principle of moral judgment. As Kant recognized, it makes sense to cast moral judgments of praise and blame on people only in the domain of freedom, where people have the active powers to cause their own acts to happen. And so we would say as an utterly necessary first principle that we don't hold people blameworthy and responsible for acts they were powerless to effect. As Thomas Reid put it, to call a person to account, to approve or disapprove of his conduct, who had no power to do good or evil, he said, it's just absurd. And Reid said, no axiom of Euclid appears more evident than this. Well, that axiom, we don't hold people to account for things they could not affect. That axiom forms the ground in our own law of the insanity defense. He didn't understand what he was doing. But it may also mark the deep wrong in principle of racial discrimination, that we are determined or controlled in our conduct most critically by race. And if we know the race of any person, we'd be in a position to draw some interesting moral inferences as to whether we're dealing with a good or a bad person who deserves to be welcomed or shunned. That is to say, the assumption is that the moral conduct of people would be, quote, determined by forces outside their control. We've seen judges writing in that vein about people being punished, penalized on the basis of race for conditions they were powerless to control. But that principle underlies so many other things where people, for various reasons, may not be in full control of themselves. Of course, there may be the most difficult questions as to whether Jones really was so deeply under medication or hypnosis or so incapacitated that he could not have performed that burglary. All of these matters are quite contingent and maddeningly variable in their possibilities. But the decisive point comes in recognizing the one thing in this mix that is never variable, never contingent, never open to question, the principle itself, that if Jones really was powerless to effect the acts in question, he cannot be judged blameworthy and responsible for this wrong. That principle will never cease to be true under any circumstances. It is a necessary truth. It will be the one thing remaining stable and readily grasped, even while everything else may be in doubt. In the case on segregation, we used to raise the question, if we separate the students on the basis of race and the performance and motivation of the Black kids go up, has the segregation ceased to be wrong? Or is it wrong in principle? And if so, what is that principle? I just tried to suggest it. Well, how many of these propositions do we have? More than people seem to realize. From that first principle, as Reid had it, one could begin drawing out a skein of implications with practical bearing on our law. So if we begin by respecting the difference between innocence and guilt, we understand that we should visit punishment only on wrongdoers, and that commits us to insisting that the evidence for wrongdoing should be assessed in a most demanding way with the canons of reason, rather than having people run over hot coals or being pummeled until they confess. And as we follow the logic, we draw the inference further down the line that people accused of crimes should have access to the evidence and witnesses against them so that they have a chance to rebut the charges. And in rebutting them, producing an accurate, producing a verdict that is substantively accurate in marking off the difference between innocence and guilt. Now, if you follow this, by this moral logic, a person would indeed have a right to be, quote, informed of the nature and cause of an accusation, to be confronted with the witnesses against him. By this logic, he would have that right in principle, even if it hadn't been set down in the Sixth Amendment. To put it more sharply, that right would simply be implicit in the very logic of the rule of law, even if there were no Constitution. But if we grasp that first principle on the matter of rejecting determinism in all its variants, we'd be at the threshold of recognizing a principle that probably runs through our cases in law more than any other. And once again, we could see the matter through the lens of that ordinary man on the street. What do you think he would say if we put this question to him? From the fact that someone is tall or short, heavy or thin, that he's dark or lighter, that he stutters, or that he's deaf, can you make any inferences as to whether you're dealing with a good or bad man who deserves to be praised or blamed, rewarded, or punished? The common sense of the matter, grasped by most people, might be explained by the philosophers in this way: that we're dealing here with attributes that are wholly wanting in moral significance, that we can't impute to any of these features, height, weight, clarity of speech, we can't impute to any of them a deterministic force in controlling and determining the moral character of anyone. Okay? To recognize that point is to recognize a truth that is anchored, you might say, in the mint of our nature. It's just the way we are. We are not controlled in our moral conduct by our height, our weight, our color. And that necessary truth, as I say, threads through so many of our cases without people quite noticing it. The most dramatic example I could give you under that head is the old case of Baby Doe in Long Island that came up in the 80s. The case involved a child, newborn, afflicted with spina bifida and Down syndrome. The parents and their doctors withheld medical treatment from this newborn. And the Reagan administration went into court. The administration did not insist that there was an obligation to inflict a futile surgery on this child in conditions where operations would be futile. But the administration wanted to know whether the decision to withhold care from that child had hinged on a medical judgment or something else. Judge Ralph Winter in the court below pointed out that a decision, say, to withhold medical treatment of a child because the child was too dark or black was not a medical decision. And if the decision here, in the case of Baby Doe, hinged on the judgment that a life afflicted with Down syndrome and spina bifida was a life not worth living, that anyone bearing these infirmities could rightly be consigned to death by withholding medical care, that was not a medical judgment, but a moral judgment. It was a matter of drawing a moral inference about a person on the basis of characteristic, a disability, that could not possibly establish whether we're dealing with a person who is incapable of living a life of moral purpose, even in a diminished state, and therefore deserved to die. Now, if that distinction that Ralph Winter and I were offering, if it makes sense to you, that there's a difference between a medical judgment and a moral judgment here, that the moral judgment was drawn wrongly from the attributes of a person that cannot possibly determine anything of moral significance. Nothing in the disability of this baby could bear on the question of whether the child had a life not worth living. If all that makes sense, well, I submit to you that the point here is simply grounded in the inescapable fact that these attributes, height, weight, color, spina bifida, are powerless to determine any judgment on the moral state of anyone. And then the question almost naturally presents itself. If we shifted the locale, if the hospital were not in Long Island, but in Tehran or Nairobi, would the judgment be any different? Would it not be just as wrong in any of these places, distant in space or time, to withdraw medical care on the ground that a life afflicted with spina bifida or Down syndrome is a life not worth living? If we recognize that simple point, we'd have recognized that this judgment of ours about the wrong of drawing moral inferences about people on the basis of these attributes, wholly wanting in moral significance, the wrong of drawing those moral inferences about people does not reflect simply some ethic that prevails in this tribe of Americans. The judgment is grounded in nature, in the laws of reason themselves, in truths that can be grasped by any functional person, as I think I've shown. And there's nowhere in the world that they would not hold true. And so without any sense of astonishment or any sense that we're doing it, we would find ourselves backing again into that N word that dare not speak its name, the natural law. It's one of the mysteries of conservative jurisprudence in our own time that so many of our friends think that if a judge departs from the text of the Constitution, he's simply winging it with his own subjective likes and dislikes. They don't think that there's a serious discipline of moral reasoning outside the text because they really come to doubt that there really are moral truths outside the text. They call themselves originalists, but they've given us a truncated version of the original understanding of the founders because they've detached the founders from those anchoring principles of natural law that they wove into their judgments. And it became then almost a matter of pride for conservative jurisprudence that the judges should not go out of their way. They should go out of their way to steer around the questions of moral substance contained in the greatest cases. So the line would be, for example, that the Constitution says nothing about abortion and marriage, and therefore the conservative judges were in no position to declare any rights on those matters as springing from the Constitution. But of course, the Constitution said nothing about marriage when the court struck down those laws in Virginia that barred marriage across racial lines back in 1967. As Gerard Bradley, Professor Bradley has pointed out, the federal government has to deal with marriage in matters of naturalization, in many other instances. It has to deal with abortion in the military and diplomatic outposts abroad and in the District of Columbia. The conservatives would not make the case for the human standing of the unborn or make a substantive defense of marriage as the union of a man and a woman. They would simply return the matters to the states and the political arena with a sense that they were simply value judgments, which could be different from one place to another, with no one less plausible for another, because there was no truth that attached to any of the judgments we might make here. But this style of jurisprudence suddenly suffered a shock last June with Justice Gorsuch's opinion on transgenderism in the Bostock case. That was the jolt that finally awakened conservatives from their benign and dogmatic slumber. Through the alchemy of textualism, Justice Gorsuch sought to show that the Civil Rights Act of 1964 not only banned discriminations based on race and sex, but also sexual orientation and the various ways that people could conceive anew their own gender identity. But as David Crawford, Mike Hanby, and Margaret McCarthy pointed out, this case ran well beyond the question of whether Anthony Stevens had the freedom to dress and present himself as a woman. To come down on his or her side was to reach the judgment that everyone around him was obliged to respect that claim of his, that he had become a woman. And if they weren't willing to speak that untruth, they could put themselves or their employers in legal peril by constituting a hostile work environment. Neil Gorsuch was the highly celebrated successor to Antonin Scalia. He was vetted and heralded as an originalist and a textualist. He was endorsed and vouched for as representing nearly the best of what conservative jurisprudence could produce. But now the conservative movement was feeling the shock of an embarrassment running deep. For in the wreckage of this case, we found now originalists who defended the rights of abortion, same-sex marriage, and transgenderism, while others had long resisted these moral novelties. But if originalism is divided on questions of this kind, was it really indecorous to pronounce the plain truth that originalism, as we see it now, has nothing to say directly on the moral substance of these matters, that it's a morally empty jurisprudence? As conservative critics offer their most serious critique of the decision rendered by Gorsuch and his colleagues, they found errors in the understanding of the precedents, the reading of the statute, but nowhere in the conservative reaction was there found any recognition that this decision struck at the very meaning of that human person that stands at the base or the root of the law. As David Crawford wrote, this was not merely a new opinion, but nothing less than a new metaphysic on the way we are constituted as human beings. For if this decision is taken seriously all around and taught now in the schools, and he asked, what is a child to make of his own parents and siblings? Is his father really a man? His mother a woman? Is his sister really a boy? And now, what really is he? The question's planted. In the run-up to the Bostock case, I predicted that the liberals would play the Lyman-Trumbull card. Lyman-Trumbull was a senator from Illinois who managed through the Senate the enactment of the 14th Amendment. And in doing that, he had to assure his colleagues up and down that there's nothing in this new 14th Amendment or the Equal Protection Clause, nothing there that would challenge those laws in Illinois as well as Virginia that barred marriage across racial lines. And he knew that if he couldn't give that assurance, the 14th Amendment wouldn't have had a ghost of a chance of passing at the time. So the original understanding of that is quite clear. I expected that progressives would simply play the Trumbull card and argue now, well, look, just as the very meaning of racial discrimination has been amplified and corrected over the years, perhaps the meaning of sex can be amplified since the Civil Rights Act, much in the way that the understanding, again, is racial discrimination has been. And so that argument could be countered by citing the way dictionaries defined sex in 1964. The firmest ground of the defense, though, was to focus again on the objective meaning of sex, anchored in some enduring truths in nature. As the Congregation for the Doctrine of Faith put it years ago, there's not always been an Italy or a Hungary, but as long as there are human beings, there must be males and females. That difference is more than skin deep. It deals with the way our bodies are constituted, with our reproductive organs, and with differences that run down to hormones and cells. Again, what we've had, I'm afraid, flying under the banner of conservative jurisprudence is a truncated originalism, detached from the understanding of the founders on the moral ground of the law. But to ask whether judges could get to today without backing into the moral reasoning of the natural law is rather like asking, can I order the coffee without using syntax? They use it every day and at every turn. About a dozen years ago, I was giving a talk at Natural Law at Fordham after my book, Natural Rights, The Rights to Choose, came out. And at dinner, the dean remarked that there was very little discussion of natural law by judges during those early years of the Republic. To which my friend Dan Robinson remarked, yeah, there was very little discussion of the alphabet either. But it was woven into everything they did. They said nothing about natural law because this was just the way they did law. In tracking their judgments back to certain anchoring axioms, as John Marshall said, are first principles, as Alexander Hamilton had it. And it finally dawned on me, Stephen Hudson recognized this, that what we've been dealing here with is what philosophers called a category mistake. She arrived in a sedan chair in the Vale of Tears, kind of confusing of the ingredients. And so to take that example, something close to what Gilbert Ryle used, let's say I have a friend visiting Amherst. I take him to the beautiful room where I teach. I take him to the library, to the Earth Sciences building, to the gym, to the administration building. And later, when we're having a drink at my house, he says, I thought you were going to show me the college. What do you think I've been doing? And now we have lawyers who follow saying, all you've shown us is the way our group of literate lawyers managed to track their judgments back to certain axioms or necessary truths that would, and rights that were there before the Constitution and would be there even if there were no Constitution. When are you going to show us how they did natural law? Right? I think we have. In that book, Natural Rights and Right to Choose, I offered a memoir, as Tom said, of that experience in passing a first act to protect children who survived the abortions. I expressed then a certain disappointment in some of my own friends in Congress who just didn't force the Democrats to defend their position, a position that would have shocked most people in the country if the news ever got out. And the media made sure the news wouldn't get out. The Democrats sought to escape their predicament by simply avoiding the argument we were seeking. The words I spoke then would apply with even more force now, at a time even more troubled as our own. And when we need even more the nerve to make the argument in public. So I'll close here with the last lines I spoke and wrote in that book. A political class that has lost the sense that reasons and arguments matter is a political class that may serve in positions as high office of state, and yet its members would have lost their vocation. Because at times, the need to clarify the principles entails the need to stage a confrontation or a debate, and they may involve at times the need to pick a fight. A political class that's persistently reluctant to show that spirited nature will produce not merely a politics that's banal, but one that is, but one that is denatured. Because in removing the conflict or removing the argument, one may gently remove as well the moral substance. Aristotle remarked in one of his most memorable observations in the physics that if art were in the material, we'd expect to see ships growing out of trees. But ships were not part of the world of causation produced through the workings of the laws of nature. Ships were part of a world governed by design, by the awareness of ends, by the shaping of reasons. We may be bringing forth now a political class more and more detached from the sense that there's any particular importance in compelling the other side to come out with their reasons and claim them as their own. And to a political class molding itself in that way, we may not only ask, where is the reason that gives meaning to political life? But where in all that is the art? Where do we find the distinctive hand that marked your work? Where do we find the design that marked your understanding, the touch that reflected the experience that you had cultivated. And where finally do we find the impression lingering through time that you were here, that you were here. Okay. Thanks. As Ronnie
Wow.
was saying, thanks for listening.
Thank you for giving that. That was wonderful. Nice. Yes, I'm seeing some nice rounds of applause. So for people who are interested in asking questions, you can either put them in the chat, or if you're interested, please raise your hand. Lewis, go ahead.
Hi, Professor. So first of all, thank you for that great talk. I thought that was pretty awesome. So I'm a little confused because, I mean, as you said, America was founded on natural law. But today in America, natural law teaching is thoroughly rejected. So I'm wondering if you have any insight as to, and I mean, in contemporary America, it's thoroughly rejected. But I'm wondering if you have any insight as to why we've seen that shift as a country who came in to the world essentially founded on a principle that it now seems to be rejected.
Well, there really is an answer, and the main thug in the story is Justice Holmes, who really expressed the voice of the modern project in law when he said the aspiration was to purge all words of moral significance from the law altogether and give us a pristine science of law that would never venture into those moral judgments, because all those moral judgments are just subjective. There are no moral truths out there. All he said, I can just tell you what I can't help but believe. And in that case, what is the law? Why does the majority rule? Lincoln could explain why the majority ruled, because an underlying principle about the rightness of being ruled only by the consent of the governed, and then the rule of the majority is the only operational form to instantiate that principle, but a majority that can't decide everything. Majority that understand this under certain restraints. But if you detach those two, you get Justice Holmes, and I'm afraid Justice Scalia. If you ask them, what is the ground on which the majority rules? The answer was, the majority can overbear the minority. In other words, it's might makes right, or the rule of strong. Now, in getting at this stuff, what I do is take the natural law has been discredited among lawyers, but we're bringing it back. And you want to join us in this project, sign on. We'll be happy to take recruits all the time. We're getting recruits and conversions among lawyers and judges. So really raising, something's going on. But so much of can this be done, as I try to suggest here, by the understanding of ordinary folks. I remember C.S. Lewis used to draw on the understanding of children. And you put this problem. Let's suppose you have a 7-year-old who's set upon by thugs in school, who steal his lunch money. Which of two possible reactions would you expect to be true? One, he assumes that the people who did it must have been right because they did manage to overpower him. Or the second one is, he feels a sense of wrong, that something there has to be justified, and that people simply cannot claim the power to that anything you succeed in doing to me must be right because you've succeeded. Well, if you understand that, my hunch, I know, would you bear me out that most kids would take the second course? They'd be aggrieved by it. Well, what you've done is when you do that, you've just walked into Rousseau's argument that you must reject might makes right. And if you do that, you're saying that this movement of exerting power over other people, imposing the law, removing their personal choice, restricting their freedom, that's something that must be justified. Now, I've been arguing lately that that is the most natural reaction. And when people take the natural turn there, they have taken the turn to the natural law. They understand these are things that need to be justified. Let me just put, what I've tried to do in the talk is to try to show you that just ordinary folk, if you gave them these questions, if Smith was incapacitated at the time, could he have been guilty? Could I draw inferences of guilt from your size and weight? Ordinary people can understand that. Let's say we gave people this question. What are your reactions? Why is it in this age of animal liberation, we are not signing labor contracts with our dogs and horses? What do you think the ordinary person would say in response to that? I think he'd be baffled by the question. What stands behind his bafflement? Well, there's only one kind of creature who can have reasons for making a contract. Only one kind of creature who can expect to make promises and honor those promises, even when it runs counter to his interests. There's only one kind of creature who can do that. But once you've said that, you've actually backed into all men are created equal, that we cannot rule moral agents, human beings, in the same way that human beings must rule dogs and horses. And the old understanding was as God rules men. All right. And when no man is by nature the rule of other men in the way that God is by nature the rule of men, and men are by nature the rule of horses and cows. And Jefferson said in the famous line, anyone who rejects that must suggest that the mass of mankind were born with saddles on their backs, that a privileged few were born with spurs on, ready to ride them. So as you say, yes, we have work to do among the lawyers who've been taught to dismiss natural law. It's always some kind of theory hovering in this cloud. What I try to do is suggest in this talk today, no, there's nothing woolly about it. As you see it bear on cases like Baby Doe in Long Island, it bears precisely and concretely. There's nothing. It's not lofting there in the stars in the heavens foggy. It's very precise. It's based on truths that are not only knowable, but are necessarily true and grasped by ordinary people rather readily. You need to have theories of the academy in order to talk yourself out of seeing what any functional, normal person can see. So again, to answer your question, the path is what I'm going to try to, a new book's going to be called Mere Natural Law. I'll try to do this the way Lewis did it, but let's starting with those things that ordinary folk can understand, even children can understand. And in that case, maybe lawyers will understand it. Okay, I'm open to, thanks for that question. I'm open to another one.
Professor Byers wants to ask a question, so go ahead, Dr. Byers.
Hi, Hadley. I teach ancient philosophy and medieval philosophy, and I've done a lot of work on Cicero. So I'm very sympathetic to everything that you say about the need for a philosophical basis. My question is, maybe it might sound bizarre in light of the context that you're talking about, the positivism amongst the lawyers today. Yeah. But actually, in the Catholic world, we have this sort of what I call a hotbed of craziness, which is integralism. And it's not only at Harvard, but now coming out of Steubenville. So I've been trying to diagnose myself where this comes from, this idea that it would be great to have a confessional state, and for me, it's very bizarre because I grew up saying the Pledge of Allegiance every day in school, and just the blessings of America were taught to me that, that we're to be grateful for this order that we have here. I wonder if you can talk about, about precisely that, why America is such a blessing in the history of politics compared to the religious wars of Europe in the early modern period, for example. And do you have any thoughts about why we're seeing this groundswell of integralism? I mean, I think it's trying to fill a vacuum, perhaps, but maybe you have thoughts of your own.
Thanks for that. That really is a good. I don't want, I don't fall into the habit of grading questions. That's a good question, though. But with this matter of integralism, I understand where it's. Oh, let's say you put it this way: do we ever imagine, at the motivation for it, did we ever imagine that we'd be living in a country in which parents could be barred by a legislature from consulting counsel if their children are confused about their gender identity. A country in which children could be led by their advisors into mastectomies and hormone surgery without the awareness or consent of their parents. We start adding things up. And it's all done by this new postmodernism, which denies any kind of reckoning of truth. We can't even talk to them about, why do you consider that child in the womb anything less than human? What is this climate change? All the serious scientists call it into question, but on the basis of these claims, you're ready to redo our life. I could see people living under this, saying, this is madness. It's a regime that no longer respects the grounds of truth, because it doesn't any longer respect the founding. Now the people think the founders were racists. The founding, well, first of all, let me say what I understand about integralism. And I think my friend at Harvard, Andre Vermeulen, who did a fine piece for First Things, saying that, look, considering the church has never had a commitment, any particular form of regime. The church can exist in a variety of regimes. And now we see a situation where people have so far drifted from any respect for the truths of religion, and have drifted, in fact, to the point of disrespecting the truth on which their own authority rests. You know, Lincoln's line about Senator Paget of Indiana, who said that the self-evident truth of the Declaration was a self-evident lie. He says, here is a man lifted to high office in a republic who has utter contempt for the moral premise underlying his position. So, okay, now I can stand people say, look, by the time we've got this, this is not tenable. But you repair is the answer as we have is that you said it's an extraordinary country. It was the only country that came into an existence by offering a claim for the rights of its people, not dependent on anything local, but on grounds that would apply universally, that anywhere in the world we go, it would be wrong to rule human beings the way human beings are compelled to rule dogs and horses. That case for freedom and against slavery will hold wherever that difference in nature remains. Hence the notion of natural rights. There'll be and so Lincoln said, Jefferson articulated a truth applicable to all men at all times. So it wasn't remarkable that there was slavery. There was slavery everywhere. What is remarkable was that this regime was founded on principles that in principle opposed that situation, that slavery disappeared from half the states at the origin, that we had a remarkable declaration in Darien, Georgia in 1775 by slave owners saying, we are embarrassed by this situation of slavery. Slavery is at odds with those principles on which we are claiming our freedoms right now. So we here resolve that we will emancipate our slaves and try to bring them into a safe footing with their neighbors. So we go into this Constitution, and there is no endorsement of slavery in principle. The word slavery is not to be used there, and we know why, because as Oliver Ellsworth said, we want no traces of this odious institution when it passes away. So we go into this system, barring the infusion of new slaves by barring the slave trade after 1808. We bar the extension of slavery into the Western territories. So Lincoln looks at it and says, if you look, all the earmarks are earmarks of a design not to promote and encourage, but to discourage and to compress. And the hope was with Lincoln that it's the oldest institution. Perhaps we can buy them out, pay people to give up their slaves. Perhaps we can make some kind of adjustment with them for the sake of avoiding a bloody civil war. Because after all, so many of these slaves running about, as he said, are running about because their owners at vast pecuniary price freed them. He said, and I would call it, yeah, for the line from the pure. And what is that thing? It's your natural sense, he said, that the black man has some natural right to himself, that those who deny it to make mere merchandise of him deserve kicking, contempt, and death. And in fact, I think if you figured out those slaves are worth about $235 million. And he says, why are all these horses, you don't see horses and cattle running at large. Why are these pieces of property running at large? Unless you have the sense that they're not really pieces of property. And then he turns and says, so now will you ask us to deny the human standing of the black man and treat him only as the equal of the hog? Why will you ask us to do what you would not do yourself? Why would you ask us to do for nothing what $235 million could not induce you to do? So, Professor, but I really appreciate it because it's a time when people are deeply confused and where the academy, the colleges are just teaching hostility to their own country. And the argument is I think, anchored, as you've seen, in these understandings of postmodernism that I dealt with at Amherst, that there really are no anchoring truths. And how do you deal with people who, if you ask a question, you must imply that there's some kind of an answer that is tenable.
Thank you so much. I'll let someone else have a turn, but thank you very much.
Okay, Sarah, thank you for the question.
Yeah, no problem.
Morgan, I see your hand's up next.
Okay, great. Thank you. Thank you, Professor Arkes, for the speech. I have to say I agree with pretty much all of it. And I thought it was a great defense of kind of objective morality. One issue that I think I disagree with most conservatives and most people who treasure the natural law is that surrounding homosexuality. And I read that you testified for the Defense of Marriage Act in Congress, I think, correct?
Right.
And in my mind, and I think there's evidence to suggest that homosexuality is a natural phenomenon. And in that case, I don't think homosexual behavior can violate the natural law. And I think that opposition to homosexuality actually comes from the Catholic Church rather than the natural law. I don't think the natural law has much to say about the issue. And I was wondering what your thoughts on that were.
Well, there are many. First of all, it's we've had many people who, with therapy and the conversion, just come out away from that life. And you ask people, well, what do you think really is determined by some forces outside the control? Would be all the kind. We have perversions of homosexual sex, right? And we have perversions of homosexual sex as well as heterosexual sex. And you say, do you think that we're, something in nature leads us to have these encounters, 20-minute encounters here and there? I think one of the problems here, if, I once put it this way in a meeting that our relation, some of our conservatives, our relations with our gay friends is affected by a kind of Henry Jameson subtlety, that we try to protect our friends from wounding words and gay bashing. And they, on their side, don't ask for a global endorsement of their way of life. Every one of us has flaws. Okay, but one of the problems occurring here is that we go back to the original argument. First, it was said, this is simply a matter of taste. Don't cast moral judgment. It's simply a matter of taste. Well, if it's simply a matter of taste, then it's met by saying, well, it's not my taste. And if I don't want to rent property, portions of my house to a homosexual couple, it's simply my taste. Until we heard the argument, no, it's more taste, not the taste, it's wrong for you to cast a judgment on that. But why is it wrong? That has never been explained. The case of same-sex marriage, it's a complicated. Once you're breaking away from the notion that the purpose of marriage is to set a moral framework, a framework of commitment to surround the nurturance of children. And even when marriages break down, that framework of commitment has the advantage of telling us who is responsible for that child. In the case of homosexual marriages, is predicated on the notion that no, we are rejecting the prospect of begetting. That's not part of the whole thing that counts as the telos, or the purpose of sex, and therefore the justification for the framework around marriage, that children may be at stake. And what's involved here is that you forego the freedom to quit this relation as it suits your convenience. Okay, once you break the connection, this was the argument that was made in those first hearings back in 1996. Once you break that connection to the function of begetting, once you detach it from sexuality in the strict sense, that strict definition of sexuality, well then the whole relation is open. Why would you say no to the people who come back and say, well, our love is woven into a larger network of 3 or 4? What's the ground on which you say that it's got to be 2, right? And if you're moving to the notion of plural marriage, you can't confine this to people the same sex. It's got to be open to mixed couples. You say, we're back to polygamy. And in fact, what we're finding here is the emergence of now polyamory. So let's say I put it back to you. I say, once we have that, what is the ground of principle on which you reject polyamory? The 3 or 4 people who now want to claim the right to marry. It's clear. What is it you would say?
I would say that as a principle, monogamy is preferable to polyamory, and I would say that same-sex marriage does that. Protects or encourages monogamy just as much as it does in heterosexual relationships.
But there is still the possibility of divorce.
Yeah.
Okay. So and then okay, but a part of people say we're not interested in begetting children. It is simply a matter of what gives us pleasure, and if it gives us pleasure to have a 3 or 4, what is there in principle about monogamy that overrides what we take to be the rational, sufficient justification for this arrangement, that it gives us pleasure? Yeah, you might think that monogamy is better, but why would you be justified in having a law that imposes that monogamy and bars me from a relation of love with 3 or 4 people that I adore? You see the problem? And this could be, and look, I have friends who are gay who are reserved about same-sex marriage. It's a shift. It opens up many of these problems if you're willing to probe a little deeper and look at the question. But it's a tangled matter. It's been with us for a while.
Well, one last thing, I would say, you basically inferred that the point of a relationship between 2 people, a sexual relationship, is procreation.
That's what it meant. That was what it meant in the first place. That's the purpose, the telos. Why do you have males and females? It's explainable mainly, solely by the fact you need that in order to perpetuate human beings.
Yeah,
okay.
I would agree, but that would, but by that logic, if you push it to the extreme, it would, you could make a law that prohibited someone from getting married that couldn't have children. For example, a woman who passed menopause at age 50 or 55, or even a man who has reproductive issues. I would say that marriage is, yes, part of it is for the reproduction of children, but another part of it is to is for connection and for love, and also to encourage monogamy, because if it's purely about creating children, then a very small portion of the population could even get married.
Here's an interesting point. It gets us back to something really that some natural lawyers rekindle for us, and that is, there is something about the joining of the bodies there. If we could imagine a woman being raped who was sterile, and there's no chance of her begetting children. And we've heard the argument Yale years ago that this should be considered just another assault. And people argue, no, this is not merely another assault. It can't beget children, but it's different. It's a different kind of assault. The joining of those bodies in that way is not something one admits to anybody passing in the street. So there's something about the bodies themselves that comes into play here. Why it is we don't consider the rape any less of a rape if the woman happens to be sterile. That's bound up with it. But again, I go back to your early point. I still haven't seen the point. 3 or 4 people love each other. Why can't you honor our love in the union we want? And what is there? But in principle, I understand the principle that tells us why we may not draw inferences about people on the basis of race. We may not draw inferences about people on the fact that they're afflicted with spina bifida. But what is the principle on which we say, for a same-sex couple, it must be monogamy when they're not interested they may not be interested at all in having children? What's the principle that confines it to monogamy?
I'm not entirely sure, but what I would say is that one sex can only happen between 2 people.
Well, no, it's not true. Not true.
It can't happen between 3 or 4 people at the same time. So it would
your imagination is restricted.
What? Sorry?
Your imagination is restricted. But I think what you're getting at, let me state your argument on the other side. It's like Roger Scruton saying, there's something about sex. Maybe this is the argument you may use, Mr. Hunt, at some point. That there's something about sex, a serious sexual relation, that demands exclusivity. Okay, so I could see somebody saying, "Look, Joe, I had an agreement with Fred to play tennis every Thursday. I can't make it. Would you go in my place?" You can't imagine the same man saying, "Look, Joe, I had an agreement with Louise to have sex this weekend. Would you go in my place?" Somehow we can sense it doesn't work. There's something about this relations that demands exclusivity. But we could see how that was all tied in with the motion of beginning. It's a little harder to argue about this. The people on the Man-Boy Love Association, that's an interesting test because we better get on to other questions, but it was there was an argument for years as to whether the Man-Boy Love Association had a legitimate standing in the gay rights parade. That is to say, there was a certain sexual orientation that the gay activists regarded as illegitimate. And if that's the case, the question must come back. If even the gay activists can regard certain sexual orientations as illegitimate, how could we be warranted in passing a statute that in a sweeping way bans all discriminations based on sexual orientation? They would ban the Man-Boy Love Association, but the Man-Boy Love Association comes back with a plausible argument. They say, look, 2 men, a guy and a teenager, we love each other. We can take precautions. We don't have the same kind of emotional problems as with children. No need, no surgery, no need for abortion. All we can tell you is we love each other, and the 16-year-old knows as much as anyone else whom he loves. See, they give on the premises of gay sex, they have a plausible argument. That's an argument that has. So anyway, I think I've told you more than you wanted to hear. We need to do, but thanks for the question, Morgan. I'll just put some things on the table for us all to think about.
Yes, thank you. Thank you very much, Professor.
Right on.
Professor, I have a question in the chat. This is an anonymous question. And it says, "Dear Professor Arkes, thank you very much for your presentation. I hope to ask the following two somewhat Kantian questions anonymously. First, to what extent..."
A Kantian question is about the imminence of ominence or something, huh? Okay.
We're about to find out.
Oh boy. Okay.
Firstly, to what extent is the natural law taken for granted by every common man a priori by pure reason? And secondly, if the basis for self-evident human right is that human beings can be held morally accountable, on what basis should be the unborn to enjoy such right? To be clear, an embryo or fetus is different from a child, since the former depends on another human being to a much higher degree. In order to be held morally accountable, one at least should have the basic capacity of reasoning.
Well, Uncle Joe, who's lost his power of reasoning, and is in a debilitated state, hasn't lost his standing as a human being. Oh, there are lots of interesting things there, but let's think of it this way. The pregnancy test is a sign that something is growing. Something there, not only powering its own growth and integrating its own growth. If it's an offspring of human beings, it cannot be anything other than human. And once we're clear on that, it cannot be anything other than human from its first moments, then we knew that the laws of homicide are virtually indifferent to the question of the size and weight of the victim. We don't take the killing of an older, larger male to be a more serious murder than the killing of a small child. So height and weight don't have anything to do with it. If you just take that line to take with Lincoln, you'd have to tell us why it is that you withdraw the protection of the law from this human being. It can't be height and weight. It can't be that we don't know if it's reasoning yet, because there are many people walking about who have dim powers of reason. And people don't lose their human standing where they suddenly lose their memory or their capacity even to speak. So it can't be that. So as with Lincoln, I'd say, if you tell us the ground on which you're justified in withholding the protection of law from that small human being, you'll find that argument will carry over. If you think that the child may have Down syndrome, you say, well, you're not wanting to take the life of people walking about with Down syndrome. And I remember one fellow in a wheelchair in Detroit years ago saying they want abortions for people who might have my disability. Okay, but once you're clear that it can't be anything other than human, then the kinds of reasons we need to justify the taking of that life must be on the same plane as the reasons we demand for the taking of any other life. You wouldn't be justified taking anybody else's life because of convenience, your convenience. If your life is in danger, that is another matter. And we could make concessions over that. But I don't know if I've lost the question. So I'm saying it's first of all, it's the, I don't know how Kant comes into this one, but it's simply that mode of principled reasoning as to why you would, and I once put this question of, let's say someone came back and said, the Civil Rights Amendments were obviously meant for Black people who'd become human. And we know now, we've been told all around us, not everything conceived of human is human at every stage. And so we send that question out to the states. And the state gives us a color wheel. You become more human as you become later. Let's color 13 to 14. Now you know how judges would handle that, right? They'd say, it's not me describing it. By doing that shift, you're removing a whole class of beings from the circle of rights-bearing beings with a claim to protection. What is there in this motion of color that can provide that justification? So what I'm saying to you is do the same thing with the unborn child. It's a human being from his first moments, nothing other. And the line that made a deep impression on me years ago was Paul Ramsey's line that everything we have genetically now, we had when we were that embryo, that zygote, no larger than the period at the end of this sentence, right? It was all there, like the allergies, perhaps our SAT scores. We have nothing genetically now. And I think people here would know enough to know if any one of us was removed when we were that zygote, we wouldn't have been the next pregnancy. That zygote and alone was us. There was what was the first part of that question again, Tom?
Sure, I think that was the Kantian part. To what extent
The Kantian part of it was, okay, go ahead.
To what extent is the natural law taken for granted by every common man a priori by pure reason?
It's not pure reason. It may even be before you have start reasoning about the matter. How does the average man get puzzled when asked we ask, why are we making contracts with dogs and horses? He may not be reasoning, but he catches something there that, of course, it makes no sense to make a contract with a being who can't reason and had no grounds for reckoning his interests and considering whether his interests are going to be enhanced by this agreement and I could be held accountable for. But the average man grasps that point at once. The average man grasps at once that he would not hold Jones responsible for something that Jones was powerless to affect. Now, another part of that question, John Courtney Murray once suggested that Aquinas' first principle, that is good is that which we're obliged to do, the bad is that which we're obliged to avoid doing. He argued, I know their friend who's answering the question, that is something grasped by ordinary people a priori. And one interesting test of it, I think, is to compare two crowds. One, the crowd that welcomed the Red Sox back home in 2004, after they'd broken the curse and won the World Series, and the crowd in Chicago that reacted after the evidence came out of a cop emptying his gun into a young black man who'd been felled. One crowd acted with jubilation, celebration. The other one reacted by throwing stones. The natural sense is that which we think is good is that which we greet with smiles, applause, approbation. We celebrate it. And the things we regard as bad, we reproach, we curse, we throw stones and things like that. I say, now to your question, I'd say, did they do this by reason? They do this by reason? Or are they doing this by a grasp of something so fundamental, things they have to take for granted, which are actually truths, necessary truths, things they have to take for granted, as Dan Robinson says, in getting on with the ordinary business of life. You may think David Hume has a point about causation, but the point has been made that when David Hume left his study and went off into the street, he made the same assumptions that everyone else did, that people caused their own acts to happen. How did he know that? Okay. It's one of those first principles that everyone would grasp. You see somebody shoot another person in the street, is your tendency to assume that the person doing the shooting caused the act to happen. I think it's a natural assumption. And you know advanced powers of reasoning to establish that point. This is one of the anchoring points of moral reasoning. Okay. I might have exhausted this audience. I remember once with architects, talking to a group of architects in Virginia. They seemed to be timid about raising questions. I said, well, if I don't get a question, I'm going to do Kant's answer to Hume. And you wouldn't like that. And I think what finally got me off the stage that night is I took Oscar Wilde's line just before he died in his hotel room in Paris when he said, either this wallpaper goes or I do.
August, you have a question.
Yeah, thank you. So my question, I guess, one is, do you have any books you would recommend, contemporary or classical philosophers that would perhaps help steep one in a more of a natural law thinking? Because I mean, my education, of course, perhaps like some other people, wasn't in that, and so I'm kind of filled with theories, so to speak. And then I guess I was hoping for maybe a more robust response to Mr. Hunt's question, because I have difficulty trying to think through a rational natural law argument, I should say, that would answer what Mr. Hunt asked, and what your question of posing polygamy seemed to ask him to give a principle, but not only to single out Mr. Hunt, but the way of the world, so to speak, today is not to hold to any one principle, but to let the argument flow with pleasure and with every direction. So it's and it would almost seem to fit the notion of the teleological argument of procreation, that, well, if you can procreate with two people, then you can procreate all the more with four, you know. So I guess and then I don't mean to belabor my time, but how much does what seems common to people perhaps affect the reception to natural law principles? Because, you know, now homosexuality and all kinds of things seem so common, and so they seem almost more natural, so to speak. And how would you perhaps answer that?
Well, I think we make a mistake if we simply identify the things that are common to us and familiar to us with the natural law. I mean, that's how slavery was justified in part in the 19th century, wasn't it? And in fact, Judge Posner once remarked that incest and infanticide must be in accord with the natural law because it seems to be a persisting part of the record of our species. That's not the approach. You know, to invoke Kant remarked that it's a serious mistake to make your way to a theory of human nature by simply generalizing about the spotty record of our species. When you do that, you start arguing that, infanticide and polygamy are infanticide and incest are in accord with natural law. I'm not sure I could improve much on what I said to Mr. Hunt, but let me take it from this angle. That after all, we begin with the notion that there is a function, necessary function for the generation of preservation of human beings. That is why we are made as males and females. Once you understand that, you then raise the question, what is the preferable state of affairs, which people go about begetting with no sense of commitment encompassing them, or a state of affairs in which people who might be generating children undertake a commitment not to quit this relation as it suits their convenience for the sake of nurturing the children who may be begotten? Look, you could see a rationale for getting us there. It's the burden of proof is on the side of those people who would yank us quite out of that arrangement. And so the question I was raising before is just, how would you explain, when we see, what is the principal ground of this that would not indeed generate other kinds of arrangements, which you could not provide a principled answer as to why you would not admit the arrangement of four, unless you would bring polygamy back? Or why would you not permit the marriage of the older man and the teenager who happen to love one another? What is it he has to know? He knows whom he loves. He knows what gives him pleasure if we work on that premise. So I don't want to repeat myself, and I'm afraid I will. I'm saying we see the structure, the fact and the moral structure that necessarily surrounds one. We could make a move, but we think we need to see I think that move would take the burden of argument. And we need to have some principal ground to explain why that is a justified move. Okay.
Jameson, you have your hand up, so go ahead.
Yeah, I guess my question is, why do you care? Like, why does it matter what consenting adults do, like in their own bedroom? Isn't that like what America's all about, and just freedom? And I feel like you're just overly focused on gay sex. I just don't understand why.
I didn't raise the subject, did I?
No, I'm not saying you did, but I mean,
Well, so I can't be the one overly focused on this.
But I feel like it's just, I mean, I don't get why it would matter to you, like, if a man and a man get married. Like, I don't see how that, like, why do you have so much of your career been focused on that?
It matters only if you think that there was a critical structure in place, a moral structure that had come quite unraveled by making that move. Now, you say consenting adults. We made a decision long ago to ban dueling, even though it had these consent, it commanded the consent of the adults. There are many kinds of things. A person who shoots heroin into his own arm, not effective. He's making a decision about his own body. We make decisions not to let people rent out their bodies to other people with their own consent. I mean, that principle itself will not last you very long. I think if you stay with it seriously, you'll find it must be. In fact, we had a word to describe that. Why we won't allow a man to contract himself into slavery and sign a contract for peonage. And the ancient word we use for that, you probably have heard before. They're called inalienable rights. Rights that we have no moral ground to alienate, even for ourselves. And so the understanding of self-murder right, if it's wrong for me to kill another person because of his race, it'd be equally wrong to kill myself if I discovered that I have an ancestor of the wrong race. See, the argument quickly moves us away from things we consent to the moral terms on which we're basing our policy.
All right, but with all due respect, I don't understand how shooting up heroin is the same as me being in a consensual relationship with my boyfriend for the last 8 months.
It's simply, I thought it took the matter of things that are just affecting myself. I'm not affecting anybody else. I'm just doing it to myself. And I'm doing it with my own consent. And here I'm doing something else with my own consent. I'm saying that itself can't carry the point. Because we've had many good reasons for barring things that people willingly do with their own consent, for their own pleasure. I recede on that one.
I have another question from the chat, and Professor Arkes, whenever you say I've had enough, we will call it there. But, and this actually has some interesting implications, because tomorrow night, Boston College Republicans will be having a political theory debate amongst ourselves, whether libertarians are conservatives. And so this question kind of gets to that point. So this will give us some good food for thought for tomorrow. So the question reads, there are some politicians like Rand Paul who believe in strong Fourth Amendment rights and robust privacy laws. Some consider him to be a libertarian, some consider him to be a constitutional conservative, and some think he's somewhere in between. Where would you draw the line between libertarianism and constitutional conservatives on the Fourth Amendment, and how does it fit into natural law?
Well, I think he's a constitutionalist, and a robust defense of the Fourth Amendment is certainly in order. But I think you'll discover, again, the matter will hinge on a moral judgment. If you have papers on a conspiracy to assassinate the president, and they happen to be in a bedroom, the law can get access to that bedroom. The law, if we thought that you were in a drunk state before you became involved in that fatal shooting, if the law needs that evidence to come to a judgment on guilt or innocence and liability, it may secure that evidence. So Rand Paul he will understand that all these, in fact, one of those notable cases when an inventive young woman managed to try to get heroin into the country by putting it into a condom and putting the condom in her anus. I regret to tell you that the law is able to get access to that piece of evidence. On the strength of the argument that, yeah, there is a wrong here that has to be investigated, matters of innocence and guilt. We need that evidence to reach a judgment. Rand Paul would argue with that. The problem for the libertarians is that they haven't quite grasped the notion that libertarianism is a moral position. So they think there's something wrong with people who would interfere with personal freedom. I said, fine, you're in the game. That's exactly what the American system is. My argument tomorrow is going to be on the Bill of Rights, that about the original concern that the Bill of Rights would have a truncating effect on our rights by teaching people that the main rights they have are the ones set down in the Constitution. And the classic liberal view is that, no, we have a presumptive claim to all dimensions of our freedom, whether I want to braid hair or shine shoes or do anything like that. And the burden falls with the law to justify those restrictions. Now for the libertarians, it becomes very important for them to understand how we define that moral agent whose liberty we're trying to protect. No one thinks that you can't move cows off the land when you're trying to develop the land. We can't impute property rights to non-rational creatures. Actually, this gets you back to Leo XIII and the argument that we impute property rights only to rational beings who can impart moral purpose to inanimate matter, have a moral ends in view for the uses of this matter. And so the libertarians too have to make a decision on whose liberty who's the being whose liberty they're going to protect. Some people say, no, it's my own personal interest about the abortion. It's what I feel about it. Or what about that other being? Well, I blocked that other being. What's the ground on which you block that other being from consideration? This too is bound up with libertarianism. So I'd say it's a good disposition. It's pretty sound, as it takes the point that we have a claim to all dimensions of our freedom, and the burden lies with the government to justify its restraints on any one of those things. But also recognizing that we still, even the libertarians, have some more work to do in establishing the moral grounds of justification by which they respect the claims of these people, but would not think them obliged to respect other beings who they may be affecting adversely, or insisting that there is, as Milton Friedman, you've got to be rational in order for us to respect your claims. If you're in you may be in a state where we can't seek your consent. Okay. So in other words, my point is that the libertarians will still have some understanding of who is the moral agent, that being who is competent to reach moral judgments, who has a claim then to have his liberty respected. Well, I think I've said enough to offend everybody tonight. Let's see.
I have a question if you have time still.
Yeah, we'll take one more.
All right. This is a kind of a two-parter, so I hope I'm not being unfair.
No, that's okay. You call the party. Let's do it.
There we go. All right. So I'm curious about your religious conversion. So if I have the facts right, you were born and raised in a Jewish household, but relatively recently even you converted to Roman Catholicism. So I'm very curious to hear about that.
Are you really?
I really am, and what that has meant for you, and like how you came to that, and what was kind of what the story was, and then also how that informs your politics, or how your politics may have informed that decision at all, or your kind of not politics, but like kind of your dispositions on things, and how those things ought to influence each other.
Well, actually, in that respect, I have letters from my students over the years, like Ned Desmond, who was stationed in Tokyo for Time magazine. He wrote me to say, that work we did on natural law brought me back to the church. The church was teaching this at a time when the schools of philosophy were getting relativistic. And I have a couple of my students who moved in through the natural law in my teaching there and moved in before I did. I am still Jewish. As Michael Novak used to say, when you're Catholic, you're at least Jewish. And we respect that early parts of the Bible. In fact, I told my late wife, I said, how many people in the synagogue in Amherst actually think that God made a covenant with Abraham? He says, maybe a third. I said, well, every serious Catholic I know believes it. So tell me where the Jews are right now. In my case, it was, I just moved in these Catholic circles. It was, people that I argued as Catholics do, and also I just got interested and took an interest in the forms. And a revealing moment came for me in a meeting of Catholic social scientists, which I attended as a kind of hanger-on, a fellow traveler. And Stuart Swetland was there. He was at Emmitsburg for a while, and he said he converted to Catholicism because of his conversations at Oxford with Robbie George and Dermot Quinn. Well, I brought Dermot Quinn into the country. I was sitting next to Robbie. I said, what did you say? Beats the hell out of me. He was resisting us all the time we were there. So I caught up with Stuart. I said, Robbie said he doesn't remember what persuaded you. And he said, no, it was Dermot. Dermot told me, you can believe anything the church tells you and not be a good Catholic. The question is, do you believe in the church as a truth-telling institution? Oh, I do. I did. You know, when the church stands contra mundum against the other currents invoked in the culture, my betting is that the church has it right. They see not the Father Burchell, provost of Notre Dame, said, the church holds up a mirror to you and says, this is what you're going to look like down the road. We've seen it all before. So when the church stands, church in 1944, in the midst of the war, makes the case for marriage and the respect for human life. What polity in the world in 1944 had a distinct reason of state to do such a thing? It's the church standing contra mundum. The final moment came when my wife and I were at the Red Mass in October 2009, the Mass we have before the opening of the courts. And we're on the way to the Hilton to catch up with the Scalias for lunch. And I ran into Father Arnie Pandula, whom I met years ago at Opus Dei. He'd now just come to town for the Catholic Information Center. And of all things, he confronts me and said, you, the most notable figure, standing at the threshold, what is keeping you back? Well, I dipped into my Bert Lahr inventory from The Wizard of Oz, and I said, courage. It's what put the ape in apricot. It's what I haven't got. Okay, I said, okay, I finessed that one, got out of that one. But then a week later, my friend Luis Telez was coming in town from Pinson. I said, well, I'll take her to lunch. She said, I'm going to Mass with Father Arnie. I said, well, it's around the corner. I'll go. I'll meet you there. And during the Mass, Father Arnie said, the one strand that connects these two readings together is courage. I says, okay, all right, okay. I got the message. You're right. So let's do it. And I did it. And it was really, one of the things that really affected my wife, if she'd lived, would have probably come into the church with me. What so really impressed her was, I couldn't imagine why it was such a big thing, where friends were driving in from Boston, flying in from Cleveland, and they wanted to be there. And the Borks were there and so on. And it was so, she's impressed by often what impressed me, the faces of people coming up to take communion. I always find that quite moving. It's we used to go to the little chapel on the Catholic Information Center, the black janitor, the woman with the mink coat. I said, as Mike Novak said, here they come. It's the universal church. It's everybody. And it's so moving. But it is the claim of truth. And the church, as I say, has provided the main sanctuary for preserving that moral teaching at a time when all other institutions have been corroded by these currents of relativism, right? I don't know if that answers your question, but gave you more than you might have wanted.
Wonderful answer.
Okay.
Thank you.
You want to take one more and then we'll call it a night?
All right. If no, I have another one, but if I
Okay.
would like to give it to someone else if they have it. All right. Hearing none. So you raised at the very beginning the state of the Republicans, and so I think it's a nice picture, and I think you're probably hopefully right about that. I was interested though in how the 2020 election and with the mail-in ballots, particularly some states like Pennsylvania, the state election, and not even
Sure.
Kathy Bookfar, who's not even, she's an executive. She's not, it's not in the state constitution. And it's not, or the state constitution says that she doesn't have the authority to do that. And so like this kind of phenomenon in 2020 of changing election laws, mail-in ballots. But the decentralization is my question. With respect to the decentralization of the elections established by the Constitution to establish how these things go, I was wondering if there's a natural opposition or what the constitutional argument is for a federal election regulations for regulating how the elections go in each state and or voter ID.
No,
If that makes sense as a question.
No, I think it's consistent with natural law. You could have a variety of constitutions. You could have a confederation. You could have a much more cohesive and centralized system. So I'm not sure there's a natural law ground for this, unless there's simply a matter of honoring that principle of government by consent. I mean, it's not that the federal government is imposing centralization on this. It simply has the requirement that the system of voting be established by the legislature, right? People, in other words, are responsive to the opinions and judgments of people in their community. It's very important that that decision be made by a legislature. And what we're seeing here is people moving into federal courts, friendly federal courts, to have that suspended. Mr. Trump faults the judges for not taking. I think they really should have taken something out of it. This was. I'm not sure that the question of standing was dispositive here. John Roberts, was quite willing to go the other way on standing in other cases. I think the concern here is, the mail ballot shifts the responsibility from people showing up and voting, and it shifts the leverage to people who count the votes. And now you open it up to people delivering whole sacks of votes, later harvesting vote. This is a hazardous thing. And it's very critical for people to feel that things are being done fairly. So I too have the sense that something went wrong in this election, and we're waiting for the fuller story to come out. I don't want to sound like Mr. Trump to say it was a disgrace, but I think in many respects it was disgraceful. But the point is, there's some people who think that this is the last election we're going to have, that the next one, if the Republicans survive the next one, can come back, they may have a chance, but some people actually think we have those, the rest, it'll be rigged next time as well, rigged with software. Well, there are people working on that question. I don't want to fan the flames of something else. But I think that is a serious question. We have, in the postmodern movement, the rejection of truth. You find people who really have no compunction about overriding claims of religious freedom. They're quite willing to impose on the Little Sisters of the Poor the obligation to fund abortions in their medical plans for their employees. I think they are not willing to respect any religious ground of freedom in people reserved about same-sex marriage. They've shown that. And I don't think they're have any compunction about removing tax exemptions from churches to make churches far more expensive for parishioners to attend. And for small Christian schools, sure, we can withhold accreditation if they don't have an outreach program for LGBT and if they're not funding abortions in their medical plans. Something like this was really working its way already in 1988, and I expect to see it again. The point is, people are in the state of illusion if they don't understand that people who respect no truth, and I just and see this all as a surge for power, are quite willing to take it to the end, and quite willing to do what is necessary. Well, it's almost like Woody Allen. I'm sorry if I can't leave you with something positive. Would you accept 2 negatives? I mean, what can I tell you that's hopeful? First of all, let me just say again. Was there one more question? Did you have one more question?
A quick follow-up, because I know in 2016 you were very much, you endorsed Donald Trump. You were on a list of, you were number 2 on the list, I think, of a number of academics who supported him.
During the primaries, he was my second favorite candidate. The first was anyone else. And no, I used to say, for discussing Don Trump, I used to use that little line from the D. Martin roasts about Don Rickles. And some people say that Don Rickles is lewd and obscene and vulgar. But anyone who knows Don Rickles knows him in his private life, knows it's just the reverse. First he's lewd, then he's vulgar. Okay. And that's, but the remarkable thing is that Donald Trump, this was the problem for the Republicans. So many good things were done. Donald Trump cannot explain anything. What we need at this moment is somebody who could explain, make the case. The man doesn't speak in sentences. He can't explain. It's not like Lincoln. He can't really take things down to the level that are philosophically penetrating and give an account of the problem. That bill of mine was to finally restore the penalties that were cut from the Born Alive Infant Protection Act. This is a matter of protecting children born alive who survived the abortions. This is the easiest one to use, and yet the networks will not report on it. Fox News will not cover it. Bret Baier asking questions of presidential candidates will never mention it. And Don Trump would never speak about this, even though it was the easiest to use. Well, George W. Bush never endorsed our bill. He spoke about the bill on partial birth abortion, but not this bill of ours to protect the child born alive. He had it endorsed by the executive wing of the White House. He never said a word of his endorsement. When we met in Pittsburgh for the signing of the bill, he said, he told me, this is a first step in the changing of the culture. And which I have to admit, I thought that if it was, you had precious little to do with it. You did nothing. And my assumption there, my inference was, in the circles in which he moved, it was just tacky to talk about abortion. Partial birth abortion is out there, everybody knew it. But to start talking about something new, about something people hadn't heard, that was something else. So, I mean, the public, I think, is reacting to systematic racism now about racial preferences. There are many things to talk about protecting human life. I was going to say that what is the concern for climate change? Is that eventually it's going to affect human lives if our oceans are overrun? Well, this is speculation. We don't know how many lives are going to be affected. But why would the speculative concern for those lives that may be lost, why would they overrule our willingness to look at the 800,000 lives being destroyed in front of our eyes every year? What kind of screening comes into place in order to do something like that? Well, all I can say is we're living in troubled times, but I'm very grateful that you all took the time and invited me in. I'm grateful for the professors who came along. And if I ever get back to Massachusetts and we're all there in person, maybe I could drop in and see you all again. But Steve Hudson, Tom Saruf, thank you very much. Thank you very much for having me in tonight.
Thank you, Professor. It'd be wonderful to have you back, and I wish you well. Thank you very much.
Bye-bye, fellas. Bye-bye.
Thanks. Bye. Thanks again.